Good morning, colleagues. As promised, that we will start at 7 minutes past 11. It's now 7 minutes past 11 according to my time. And now we are starting. The ANC in its Polokwane conference adopted the resolution that appropriate mechanism must be urgently established to pursue the priority of establishing an adequate pool of judicial officers who are steeped in and reflect the progressive values of our constitution. And again, in its fourth National Policy Conference held in Mangaung, the ANC reaffirms the position that the branches of the state are co-equal parties entrusted with these distinct constitutional powers in their quest to realize the ideals of democratic South Africa. Each branch of the state must therefore observe the constitutional limits on its powers and authority, and that no branch is superior to others in its service of the Constitution. Title discussion document on the transformation of the judicial system and the role of judiciary in the developmental South African state. The discussion paper was released in February 2012 by the then Minister of Justice and Constitutional Development, Minister Jeff Hadden. Accompanying that document, Minister Hadden framed the discussion paper as part of the 15th anniversary of the final constitution, stating as follows. On the 4th February 1997, the Constitution of the Republic of South Africa 1996 symbolizing the birth of South African democratic state founded on the supremacy of the Constitution and the rule of law. It is befitting that we today publish the discussion document on the transformation of the judicial system and the role of the judiciary in the developmental South African state in remembrance and celebration of the 15th anniversary of the supreme law of the Republic that positively changed the course of South African history, close quote. Those were the words accompanying the release of a document titled Discussion Document on the Transformation of the Judicial System and the Role of Judiciary in the Developmental South African State. That document was released in February 2012 by the then Minister of Justice and Constitutional Development, Minister Jeff Hadden. Looking at all the resolutions that were taken around the transformation of judiciary and the discussion documents that were released by the governing party, the question still stands. Is the judicial system transformed? Welcome to our session today. The session is hosted by the Progressive Socio-Economic Investment Institute. I am the founder and the trustee of the Progressive Socio-Economic Institute. The views that are raised in this platform are the views of the participants and the panelists and don't reflect the positions of the Progressive Socio-Economic Investment Institute. I am facilitating the session as the founder and the trustee of the Progressive Socio-Economic Investment Institute, and any of my views don't represent any organization outside Progressive Socio-Economic Investment Institute. Colleagues, today we are honored to have in our midst Advocate Mogale, who is also a commissioner at the Commission for Gender Equality. He's one of the panelists, and later will be joined by the president of the Black Lawyers Association, President Mashutu Gudama. Without a waste of time, I'll allow Mogale to make her presentations, and then we can engage on her presentation. Please take note that this session is also being streamed live on Facebook, and we'll take questions from the Facebook also. Participants who are in this webinar, feel free to take notes so that after the presentation by Advocate Mogale, you can engage her or make comments on her presentation. Over to you, Advocate Mogale.
Thank you very much, Commissioner Rakolote. I know you are wearing a different cap, but I'm used to calling you Commissioner Rakolote. I'm particularly pleased by the fact that this topic is still at the center of the table rather than it being shifted to the side. To answer your question in one word, is the judiciary transformed? The answer is just two letters, N-O. No, it isn't. When you look at the definition of transformation in the dictionary, it's defined as change in form, appearance, nature, and character. I'm not sure if we can say that our judiciary has changed in form, appearance, nature, and character in particular, because character goes to the content. That is why I actually am saying, no, it is not transformed. South Africa is one of the few countries where transformation was identified as a constitutional and legal imperative and a socio-political imperative to redress the injustices of the past that have been openly recognized and accordingly condemned. So we do not have the battle that other countries have, where some people in power still have to be convinced that there is no transformation. We as a country have said, yes, there is a need for transformation because of where we're coming from. Transformation implemented and based on a number of pillars, but I'll point out the four that I will use later. The first one would be your numbers and quotas. The second one would be capacity building. The third one is infrastructure and resource development. And the fourth one is sustainability. I'm mentioning numbers because sometimes we tend to shy away from numbers and quotas. The very same people who do not want transformation are the ones who made it feel like when you're talking numbers and quotas, it actually is a swear word. You are saying there is no merit. But numbers are actually a good and easy way to see and motivate that and monitor that things are moving in the right direction. But that has got to be accompanied with things. When you talk about capacity, it's to actually build the required skills to where we want them to be. Your diversity training, mainstreaming, amongst others. Again, capacity building, we tend to look at it as almost like it's the one group that has to be brought to the other levels group. No. Once you are talking about transformation, you are changing the form altogether. So both the groups have got to have their capacity built to a certain stage that is acceptable to the broader society of South Africa. Infrastructure and resource development. It basically is to create an enabling environment for those propelled forward to thrive and excel. It must not be left for people to feel that they're being accommodated in a foreign environment. And this is why transformation in most instances fail. The infrastructure and resource environment gets left as is, and people are almost like invited in, and it is presented almost like it is privilege, whereas they've got to find a new environment altogether, and those who were there are also supposed to find themselves in a new environment altogether. There's got to be sustainability. This has got to be a permanent feature when we talk about transformation. Transformation in itself is not an end, but a beginning. And it is a moving goal and never a standstill, because at all times, transformation has got to be responding to the science of the time.
As Taurus Capital,
apologies for that. We'll mute in. Kutama, you can continue, Advocate Mogale.
Okay, my emphasis on these pillars is to drive home the point that transformation has a beginning and a far off long-term end that should not be underestimated or taken as easily attainable. It is about scrapping certain laws and practices, putting new laws and practices in place, reinforcing new actions and practices in order to normalize and mainstream new changes brought about. It's about discouraging and even reacting decisively to laws and practices that continue to ignore or undermine transformation. The judiciary has an important role to play in safeguarding and protecting transformation, as according to its duty outlined in section 174(2) of the Constitution. On the other hand, the judiciary has to lead through its work to bring about transformation. And on the other, it has to transform itself. On the overall, the judiciary has shown a good understanding of constitutional imperatives of transformation in terms of the content of its work. Discourage and punish and defend those who undermine, to discourage and punish those who undermine transformation. However, the main challenge has always been about the internal transformation. To give just few judgments where the judiciary has shown that in terms of its content, they have transformed. You have the Makwanyane case, you have the Treatment Action Group case, you have the Carmichael case versus Minister of Justice, Safety and Security in 2001, and we have the famous President and others versus the Grootboom, which are regarded as groundbreaking judgments that have actually brought about transformation in terms of the content of the work of the judiciary. It therefore means that the judiciary has got a duty to have two parallel processes that they need to embark on, one outward looking and another inward looking. The first one must bring life and justice as a spouse, to bring justice as espoused by our forebears and drafters of the Constitution. The second one must be a process to ensure that those with a deeper understanding, commitment, conviction are brought into the judiciary. So it's a double process, adjudicating in a progressive, transformative way, but also bringing on board those who will make sure that that happens. This means it cannot be business as usual with the usual people in the judiciary. Who are the usual ones, we may ask? It is largely, if not exclusively, white males, older in age, who started off at a particular basic education school, then went on to study law at a particular universities and entered the profession usually with the help of their parents who are in the profession, relatives who may be in the profession or know other people who are in the profession, family friends who again are in the profession or know people who are in the profession. But all this would be people from their own race. This is clearly evident when you look at the judges in the 50s right up to the 80s. The judiciary was lily white, mainly male-dominated, and only lawyers from particular of a particular social strata. With the advent of democracy, this began to change. Other racial groups and gender was accommodated. I use the word accommodated deliberately because the status quo largely remained in place. This was evident through the racial tension that some emerged during the legal debates, such as the counter-majoritarianism debate in the Makwanyane judgment. Part of this judgment talked about Ubuntu as a value base that must guide us when considering death penalty. This was specifically presented by the then Justice Yvonne Mokgoro. According to some academics, colleagues on the bench, and peers in the profession, this was not seen as legal enough. As far as they're concerned, Ubuntu was just something that happens out there. You cannot bring it into the court. The court only has got room for law and nothing else. It was later embraced when her colleagues, such as Judge Arthur Chaskelson, embraced and emphasized it as a valid viewpoint to be considered in the deliberations to abolish the death penalty. Today, those of you who are familiar with that judgment of Makwanyane will know that Ubuntu is a key reason why the death penalty was actually abolished. Justice Mokgoro herself was the first woman to be judged at the Apex Court and later became one of two when Judge Kato Rogan joined as a white woman, and then Judge Nkabinde followed later. The court still lagged behind in terms of women representation, as its most promising year, which was 2000, the court had 3 women. Which was before 2000. The retirement of Judges O'Regan and Mokgoro left one judge who was then later joined by just one other African judge, Judge Kampepe. This meant that the representation of 3 women judges out of 11 was actually taken down to 2. But it also meant that the 2 African judges who had always been on the bench, there was never a change for a significant time. The fact that for that tenure there was 1 black woman and 1 white woman is an indication of the unchanged status quo the judiciary operated under until recently. Almost to say, bring on board 2 women, 1 black, 1 white, or let's have 2 blacks, so that we're seen to be working towards transformation. This is what I called above being accommodated in a foreign environment for the picture to look legitimate and acceptable. Let us not forget that the appointment of Judge Mokgoro and others later was as a result of the concerted effort of the government through the Judicial Service Commission. This further confirms that transformation cannot happen successfully without the relevant infrastructure being put in place to make it happen. This was in line with Section 174(2), which I mentioned above, which states that the need for the judiciary to reflect the racial and gender composition of South Africa must be considered when judicial officers are appointed. Therefore, the Judicial Service Commission was actually put in place to ensure that this provision of the Constitution is achieved. There has definitely been a movement as a result of this provision and a body that is tasked with making sure that the vision is realized. However, this is a moving target. According to statistics between the period of 2010 and 2017, the figures are as follows. We have, in 2010, we had a total of 221 judges. Out of those, 167 were male and only 54 female. This was a 74-24 percentage scenario. In 2012, 2 years later, we had 233 judges in total, 168. It actually moved 1 notch up, although the females increased, and therefore, figuratively speaking, it brought it down. But it was 168, 2 years later, with 65 being female. So the percentage of female went up from 24 to 28. 2013, you had 241, which was 71% against 70 females, which was just 29%, 1 percentage notch from the 65 that was the year before, which means only 5 women judges were actually brought on board. A year later, we had 243. Out of those, 164 were still male and 79 were female. It went up to 33%, and for male, it was 67. 2015, it was 240 judges. Of the 240 judges, 159, which is 66%, was male, and 81, which is only 34%, was female. And then in 2017, you had 240. Of those, 151 was male judges and 89 female judges, which means it was 63% against 37%. At face value, this looks like transformation is on track, despite the fact that an increase is consistently between 1 and 2% per annum for between male and female judges who are recruited to the bench. When you consider the actual racial demographics of the South African population, the distortion and slow pace of transformation becomes even more pronounced. According to Stats SA, with the 2019 figures, 80% of the population of South Africa, 80.7 is Africans, 8.8 colored, 2.6 Indian/Asian, and 7.9 white. However, when you look at the racial breakdown of the judge gender and what's that racial breakdown of people who are on the bench, then it gives a different picture. In 2010, for example, you had 9% Indians, whereas they occupy 2.6% of the entire population. Then you had 10% of colors when they are 8.8%. And then you had 42% of whites when they are only 7.9. And then you had 39% of African when they account for 80.7% of the population. This increased somewhat, but not significantly, because in 2017, you had 9%, that 9% was Indian, so which means the Indian population in the judiciary has not changed in a long time. Ever since, it has always been 9-10, 9-10, 9-10. It's almost like all the Indians who retire, who die, who leave the bench are actually replaced by fellow Indians. That in itself gives you an idea of what is happening internally. Then again, in 2017, you had 10% of coloreds being on the bench, and this despite 8.8%, as I said. In terms of the white judicial officers, you had 33%, despite them being 7.9. And the African population in 2017 moved from 2010, which was 39, to only 47. So it was only 8% increase during all that time. Yet we account for about 80% of the population. So this actually gives a different picture, but also a clearer picture of how the land lies in terms of judicial transformation. We cannot rely on being only 47% when we the rest of the 53% also is in the sector to account for 80% in most cases of the criminal statistics and picture. The adjudication is mainly on the 80%, yet we are only 47, and the rest of the 53 is actually outside of the African races. Then the big question becomes, why is the picture so skewed towards white and males in particular, as I pointed out in the earlier statistics? The answer lies at the start of the race, if I could call it that, no pun intended. Consider a young African child, girl child in particular, who has a slim chance when he starts basic education and finish with a few or no interruptions, unlike her counterparts from the other groups. The same young African child has a lesser chance of getting into a university to study a career of her choice, unlike her counterparts. This is because her matric outcome may be affected by where she comes from. It may be a township, informal settlement, etc., and the disruptions alluded to in the first point. The young girl who at matric would have been a young girl now will most probably, if she gets into varsity, study a quicker course to finish and go and work. Often it is to work to take care of her family, and sadly, in other instances, it is to work to take care of her own offspring. If she ends up studying law, she may be faced with serious financial constraints that will affect her performance throughout her degree. This means that she may not get into a particular law firm to do articles and thus have a slimmer chance to ever get in the training that is required to be a confident professional and one day sit on the bench. Inside the law firm, if she gets in, she may be given less opportunities than her counterparts. That culture is often being accommodated in a foreign environment, rears rears its head again. Being at the office at 6:30 and knocking off at 9 at night may not be an option. It has nothing to do with lack of commitment or laziness. It's purely about safety and lack of resources. Yet, in most instances, when such clerks, in this case being article clerks, are sidelined and excluded, their situation is often regarded as laziness and or lack of commitment. When she completes her training, she may not be retained or is retained because of statistics to get work from government with no support nor any effort to propel her forward. Throughout this period, her treatment by others send a message that you as an individual are not good enough, you can never make it, you don't belong, you are just being accommodated. This results in young Black lawyers hopping from firm to firm, or worse, getting out of the profession. They may get out not because they want to, but because the system has put them in a disabling environment to deliberately frustrate them to exit, but without them having said, please exit. How then will this young professional Black woman ever become a judge? The solution is in, number one, numbers, as I said. But we must move beyond numbers. Numbers are easy, but equally easy to use to undermine, equally easy to use to undermine the principle of transformation. We know how BEE has actually been undermined because of numbers. A lot of law firms have got excellent numbers, very good numbers, and those are working only for them to bring in income and briefs from government and other places, and not to bring about transformation. The second one would be monitorable benchmarks. Why is government giving only white firms all their briefs, or at least most of their briefs? That should be a question that we ask ourselves. Those briefs bring with them opportunity, learning opportunity, opportunity to appear before a court, building of confidence, opportunity to draw papers, and a whole lot of other opportunities that Black young professionals, especially women, hardly ever get. We also need to actually bring about the solution of public accountability of both government and all those law firms getting briefs from government. By public accountability, I'm talking about disclosures of briefing patterns and reasons why. It is important that government, when they say we're briefing company AB, we need to understand that they're saying company AB is an expert or has got a group of experts in that area, and therefore we cannot brief every other. But just like with other BEE measures, we need to have the situation demonstrated to us that we have tried but could not find the person who does this. So in terms of Black firms have got now to be the first port of call, and only after they have there has been failure should it go to the white law firms. Otherwise, opportunities never move away from those who have already benefited for so long. We need to know who has those powers inside government, because sometimes when you ask, you get told that government said that we must be briefed. We need to know who has those powers inside government departments, and how such powers continue to be used to benefit only a few. It is only in South Africa where law firms own buildings in the most expensive mile in the continent in terms of property and reality estate. Sandton City has become the hub of law firms. This is unheard of, even in first world countries like your UK, your US. A lot of the law firms are in the periphery because the way briefs are dished out is different. Here in South Africa, you have law firms owning, not renting, owning property in the richest mile in our continent. Sadly, this they afford because our government is enabling it through selective briefs. This selective briefing patterns results in continued advantage for the historically advantaged groups. The fourth point would be your controlled opportunities. The issue of acting judges and acting magistrates has to be controlled. I'm using controlled openly for a lack of a better word. That it is a training ground, must be open to all in a systematic way. It cannot be that to act as a judge or magistrate should be a personal hassle. It therefore means that those who know people in the bench will be the ones getting the opportunities. Again, this reinforces exclusivity, not of merit, but of networks. So the 9%, the 10%, the 47, the 39% will continue to bring on board their own. And an indication of this is that 9% that for 20 years or 10 years has not shifted. It sits there, which means it is the very same people on the bench giving their own opportunities. We also need to look at controlled mentorship. Currently, articles are left to the individual law firms to provide and report on the programs themselves. There has to be a uniform program that is monitored by the Legal Practice Council to ensure that clerks are exposed to the same training no matter which law firm they're at. The confirmation of such must be in the hands of independent bodies such as the LPC, with regular audits and checks on content and variety. It remains a source of disgruntlement for many Black junior attorneys who do articles but don't come out the other side with the same exposure and training as their counterparts. It is only of the best kept secret that young Black A students are recruited in their final year to go to the big law firms with a lot of fanfare and excitement from themselves and their parents, only to find that they get there and are expected to be assistant to their former classmates, collect dry clean sometimes, and even buy lunch and do photocopy for those former classmates as they're preparing to go to court to get the much needed exposure. Sadly, the photocopying that they do is for a brief, in most cases, that comes from government that this young girl votes for, and the law firm most likely does not vote for the same government. In conclusion, I would like to add that it is important that activism continues. Activism towards real transformation and not accommodation. Activism to continue to put systems in place to move from individual hustle and reinforce group rights. The definition of this activism must be to bring to life Section 9 and Section 10 and Section 174 of the Constitution, which is the right to equality, the right to dignity, and transformation of the legal judiciary. The judiciary must dedicate time to look inward beyond their numbers and scrutinize how each one of them got to where they are and be honest about their journeys to ensure that those who come find a better and continuously improving transformative environment. Thank you.
Thank you so much, Advocate Mogale. Very informative. And some of the information really is heartbreaking. In particular, when you talk about people had to do photocopies and tea and collect dry cleans for their former classmates. And they're not given opportunity to learn, even though they are taken as interns or people who have to come and do articles. Most of their time, they spend time there doing tea and photocopies and collecting dry cleans instead of learning and going to court and learn. Very sad. The other critical element that we've raised is that government itself is not fully decisive on the issue of transformation, because most of the briefs that are given to these big law firms that are mostly owned by white males comes from government. That's your assertion or submission. Thank you so much, Advocate Mogale. I'll never call you with another title today. Thank you so much, Advocate Mogale. We have lost the president of the Black Lawyers Association because he's in Limpopo. I don't know if he's struggling with his connection. But while we are waiting for him, colleagues, that is the submission from Advocate Mogale, questions, comment, inputs. that you want to submit to Advocate Mogale, and proposals on how can we make sure that there is transformation in the judicial system and get rid of being accommodated. There must be real transformation in theory and practice, not this practice of just being accommodated. Any inputs, comments from colleagues? So that Commissioner Mogale or Advocate Mogale can respond. While we are checking for comments, inputs from colleagues, there's a submission in Facebook by Pinky Nano. She says most of the times numbers are achieved, but decisions are still made by those who were dominating in that space, meaning in the past. And yes, it looks like they're still dominating because decisions are still being made by them, because the numbers itself don't translate into transformation. Any inputs, comments from colleagues? And I know some of the colleagues who are here are in the legal fraternity. Maybe they don't want to comment because it might jeopardize their future. But anyway, comments, colleagues? While we are looking for trying to locate the president of the Black Lawyers Association. Another question from Facebook is that what needs to happen in order to achieve real transformation that benefits the Blacks in particular and Africans in general? What needs to happen? That's the question, Advocate Mogale. What needs to happen?
I think what needs to happen is actually what was put in place in relation to BEE procurement in particular, where we go beyond looking at and ticking certain boxes. We do it, but we ultimately go beyond it to find out the impact of the briefings internally. We need to have a structure of that sort, but not for getting the work, but also for doing the work. We need to have a situation where government, when it gives briefs, needs to know how many people of color, how many women, how many this, how many that, how many Africans, how many this have worked on this brief, how many went to court to represent, or better still, even put unequivocally and unapologetically that we would like a 80.7 in terms of the.
We have lost you, Advocate Mogale. We have lost you. We can't hear you. We have lost your sound.
Is it?
Yeah, we can hear you now.
Oh, okay. I was going to say, even unapologetically prescribe to those law firms if they feel the law firms have got the expertise that they need. But secondly, we need ourselves to hold government accountable. We want to know why is it that a law firm that does 1, 2, 3, 4, the same brief that is being given to a white law firm, is not getting that brief. We need to start holding government accountable. So it must be a two-way street. That is why I was saying open and transparent accountability. But also to have confident people come out of all those law firms. We need to have the LPC intervene and say, people who come for articles must do the following, and they must do them thoroughly. And it must not be the law firm that responds and says, we have done it, but rather measures that are put in place for independent outsiders to come in and ensure that that is being put in place. Because when you look at things, the situation now, colleagues, you find that there are a lot of people who come out.
We have lost your sound again.
Oh, sorry.
Yeah, we can hear you now.
Okay, who come out of the law firms having completed their articles, but who can never draft, who spend 2 years, sometimes a year, who have never set foot in court, who have gone to court, but are accompanying others who will argue. So you actually get reduced to an administrator in the true sense of the word. So government needs to put in place measures where we agree on certain of the demands, but government will not do it because they are benefiting from looking the other way. So it is important that we as the bodies, your advocate societies, your Black Lawyers Association and all of those, to actually put in place and say briefs have got to be given in this way. There's got to be an open process. There's got to be so many 80% in white firms dealing with all government briefs. There's got to be this, there's got to be that. All those things we've got to put in place ourselves and monitor.
Thank you so much. I don't know if you will respond to this question coming from Facebook, from Lesego Makubela. The question is the judiciary captured? Can our judges be bought or be influenced? I don't know if you have got a direct answer to that question. Can the judges be bought or be influenced?
I'll answer it in a very superficial way to say there's a lot at stake for judges to be bought or influenced, because the profession, even in the profession of advocates, demands that we report on each other should there be anything untoward. In fact, that is why that thing came out with regards to Judge Bess Nkabinde and the other colleague. We are obliged to report each other. So there is a lot at stake. But when you look at what the climate that is happening now, it is also very easy for people to allege that, because I think a lot of people do not understand how adjudication happens. The classic example is your bail situation, where people say, why did he get bail? Why did it get bail? When the person has actually not yet even been charged of anything, is just being suspected. So there is a lot of lack of understanding. But usually when you lose, sometimes it becomes convoluted for a lot of people and confusing and very involved in terms of reading judgment and all of that to understand how did we get to this. We sometimes actually read those judgments and you find that it actually is pretty straightforward. It was a fair judgment, but the other person on the other side. So because of its emotive space and environment, it is very easy for people to say judges can be bought, judges are not what can I say, neutral as they should be. But lastly, we've found that our own judges now are increasingly playing in the political space, where their comments are not those of somebody who's supposed to be above internal battles in political parties and intra-political parties and interpolitical parties. Thanks.
Okay, then the other comment comes from Mikateko Maluleka. Says, I agree, the briefing pattern is the biggest challenge. And when they brief Black lawyers, they take up to 6 months before they pay. The tribunals like the Competition Commission continue to brief white people and making them experts in the field. Or when they brief Black people, it is on small matters, overseas matters go to white people. And this question this question I will not pose to you, because today you're not here as a CGE person, but this person, it says, what is the CGE doing to monitor and investigate the briefing pattern? So today you're not here as a CGE person, therefore this question is not relevant to you. So, and he continues saying, judges are not bought. The challenge is that sometimes they dissociate themselves from the humanity. And that's submission from Mekateko Maluleka. Colleagues, any comments and inputs from colleagues who are in the webinar? Let me go to Facebook and check other comments. The other comment is or input is that the Department of Public Service has passed a policy on regulating an appointment of foreign nationals. do you think that a similar policy has to be in place in line with briefing of advocates? To say, if you are going to, in line with briefings, if you're going to brief a particular race, you should be, or you must provide evidence that you have checked around the black law firms and none of these black law firms has got that capacity of handling that matter. The question is, do you think government has to have that law which says first point of call must be briefing black law firms? And if you're not going to, if you don't get a black law firm that specializes in that case, then you can go and brief other law firms of particular race. But you must provide a proof which says, I've checked around, I cannot find a black law firm that handles this type of cases. Now I'm going to brief other law firms owned by particular race. Do you think that can be proper to have that kind of a policy?
Mr. Rakolote, yes, I agree with the suggestion. It actually is long overdue. In fact, I alluded to it in my submission. However, at every point we need to check the constitutionality of it. The constitutionality of it you check by actually saying what would be the purpose. If the purpose is to bring up a group that had been excluded, if the purpose is to bring in line people who had actually been on the sidelines and mainstream them, etc., it is in line with the Constitution and it can be done. This, however, in most cases will be effectively done with government briefs because private people have a right to choose a lawyer of their own. But with government, they have an obligation to walk the talk, and that would be walking the talk.
Thank you so much. Let me go and check other comments from Facebook and SMSs. One SMS says, Advocate Mogale, what do you think should be the role of higher institution of higher learning in ensuring that there is transformation of the judicial system? I don't know if that question is clear. What will be the role? What do you think should be the role of the institution of higher learning?
To a large extent, the institution is on track, albeit left behind. The recognition of fees and how fees make or break people's futures is one such. But it needs to go beyond fees. It needs to go into the lecture rooms. It needs to go into the faculties. It needs to look at who is teaching. If it is the right person who is teaching, how is it teaching? But also to break down, what do we mean by the right person? You've got a university such as UCT, where only 5%, I think it's 5 or even less, of the African academics in that institution are local African. And one wonders if you have the majority of them not being local African, if they actually will have the conviction and commitment that I spoke about earlier to actually see to transformation. It may not be out of lack of political conviction or commitment or not understanding, but actually not seeing the imperative because they cannot, in a straightforward way, identify with where the country is going and why the country put that imperative. So it is not good enough to say we are covering your fees. You must be in a residential, what you call it, that enables you to study. You must be in a classroom that enhances your curiosity to learn and removes everything else and makes you focus to learn. And you must be able to look at the person that is teaching you and feel that I am being understood. I understand we are on the same playing field in terms of where we are going together with the person who is actually teaching me, rather than the adversarial relationship that we find in our courtrooms. Just without taking time, I have a friend who studied in the UK, and he was saying to me that she actually got a shock when she got to one of our universities, how adversarial the relationship was between students and lecturers. Whereas in other countries, it is an indictment on the lecturer if their students fail. In South Africa, it almost is like an epaulette and a medley that your students are finding your course hard and you are hitting them hard and you are giving them a run for their money. It is sad, but it is a true reality. And the institution of higher learning, Department of Higher Learning, Higher Education has got to deal with that.
Okay, then, we are about to close, but there are some SMSs that are coming, and I will take few of the last one. You spoke about who is teaching, but what is your view of what are we teaching in terms of the curriculum?
Oh yes, absolutely.
What is your views? Should the curriculum also be transformed to reflect our society than the Western norms and society? That's the question. Says, do you think the curriculum needs to be transformed?
Absolutely, the curriculum has got to be overhauled. I'll tell you why. Some of the people who end up getting articles are people who, students, your age students who are mastering contract, who are mastering gas law, who are mastering all these complicated, who get A's in evidence and this and that, and they get taken to these law firms because of those good results. But when you look at how or where they would use that, they wouldn't be able to use it anywhere. In fact, human rights, your street law courses and constitutional law and all of those are actually seen as a second layer, almost like your soft content, what you call it. But when you look again, going deeper into the curriculum, you find that the basis of the value of those courses or subjects is actually around the work that was done or that is to be done to benefit a certain group. You master banking law, you are there. But whether you master constitutional law or not, it does not matter. But the curriculum itself, coming back to the curriculum, it has got to be overhauled. We removed Afrikaans, fortunately, as a requirement, but you still have judgments in courts that you get given and it gets presented in Afrikaans. These are old judgments, but one wonders why are they still not being translated? The official languages of our courts is still English, and the rest of them are translated. It may be for ease of operations, but there's all of that needs to be done. Roman Dutch law. Why are we still teaching Roman Dutch law and alleging and claiming that that is how law was introduced in our country when we have always had traditional legal systems that adjudicated and resolved disputes without Roman Dutch law? Yes, there is a need for overhaul.
Thank you so much, Advocate Mogale. Colleagues in the Kitumetse Mahlangu raised his hand. Now, Kitumetse Mahlangu, you can come in now. I thought we were closing. Kitumetse Mahlangu? Kitumetse Mahlangu, the floor is yours.
Advocate, I just want to find out what criteria is used by whoever is appointing attorneys or advocates in an acting capacity.
My submission, Kitumetse, I did allude to the fact that it is more networking.
We can't hear you, Advocate Mogale.
Oh, sorry.
We lost you.
Yeah. Am I back now?
Yeah, you're back.
Okay. I was going to say in my submission, I did mention that it is actually more of networks and connections rather than merit. You go and act because you hustle your way through the judges that you know and request here and then, request here and there, and be seen in court, and literally it's hustling. much more than merit. And that is why we need that controlled deployment, where we could say people who have been in the bar for so many years need to be exposed to acting judgeships. People who have been attorneys need to come on board and be exposed to magistrates, because with magistracy, that is where you're exposed to adjudication. And ultimately, you can actually end up being a judge without being a magistrate, but you need that exposure. We can also say people who have been attorneys for so many years can actually go and act as judges. There's so many people who go and do the aspirant judgeship course and they never get called. Besides people being told, if you do the aspirant course, you are in line to be called, because the calling to come in and help is about hustling, about who you know.
And I won't be wrong. Thank you, Kitty. And I won't be wrong to say the hustling and the networking sometimes includes patronage.
Oh, absolutely.
There's an element of patronage there, because you said sometimes it's not on merit, it's just about who you know.
Yes, yes, absolutely,
okay.
Absolutely.
Last questions from colleagues who are on the webinar, so that we can release Advocate Mogale. We have been here for, we organized this session for an hour. Last questions, inputs from colleagues who are here. In the absence of questions and comments, thank you so much, Advocate Mogale, for accepting the invite to deliberate on this topic. It's a very sensitive topic. Sometimes people run away from engaging in this topic, but we need to discuss and say, how can we transform our judicial system? If we want to transform society, we must transform all sectors of society. And the judicial system cannot be left behind. It must be transformed for the benefit of all of us. Thank you so much for accepting the invite. We are so humbled from the Progressive Socio-Economic Investment Institute to host you. And we really appreciate your time. Thank you so much. To all the participants who are part of this webinar, thank you so much. For all those who are in Facebook, thank you so much. We will share the YouTube recording of this webinar. Thank you so much and have a lovely afternoon.
Thank you.
Yes.
Thank you. Thank you, Advocate.
Thanks, Kitty Metsi.